Good morning, everyone. Thank you for joining today's presentation, which is going to be it's going to be focused on Connecticut's home care, protecting your assets in case you need long-term care. And really the focus today is going to be on, in general, aging in place. So I want to just thank everyone for coming, and thank you to the Essex Library for hosting today. My name is Erin Duques. I'm an attorney at Topeka Daly Pope and Perry. So we're a Connecticut law firm. It focuses on estate planning and elder law exclusively. We also do probate litigation as well. And we have offices throughout the state, but I am primarily, I work out of our Madison office, so not too far. So I welcome questions. As Elizabeth said, well, if you could type them into the chat box and we will address them at the end of the presentation. Okay, so why are we here today? So we're talking about long-term care costs, and the reason is because here in Connecticut, we have the second highest long-term care costs in the United States for our nursing home care. And 70% of people in Connecticut age 65 plus will require nursing home care, and 52% of these people will require at least 1 year. So this is something that is impacting a lot of people, and it's costing quite a bit of money. The average monthly cost is about $15,000, which is about $180,000 per year, which, as you can see, if someone does need an extended stay in a nursing home or does require a 24-hour care at home, then this can get quite costly. So we're also seeing that people younger are requiring nursing home care. So people ages 55 to 74 has increased 23% for nursing home residents. And that is in part due to memory care, the need for memory care, early onset dementia, and those types of issues. But the good news is that here in Connecticut, you can, if you don't have the resources to pay for care, including at home, there's the Medicaid program that is available to help pay for those costs. So who is paying for nursing home care? So if you can see by this chart, 73% of nursing home costs is being covered by Medicaid and 17% by Medicare. 10% is actually paid by private pay. So most nursing home costs here in Connecticut is being paid by Medicaid. So what is Medicaid? It is a means-tested program. So it's a program under the Social Security Act. It's funded both by state and federal dollars. It's administered individually by each state. And the premise is that it pays for care for individuals who don't have their own funds to do so. Here in Connecticut, there's the home care program. So it also pays for care at home, which we'll talk a little bit more about in a few slides. So to qualify for Medicaid, there are certain factors that are considered, and they are assets, income, and whether or not the applicant has transferred assets. So the assets are, the asset limits for an individual is $1,600. So that means that to be financially eligible to qualify for Medicaid, you can have only $1,600. This is the person who is applying for Medicaid. With respect to income, for someone who is living at home and getting care at home, they can keep up to a certain amount of income, and the excess of that income has to go into what's called a plan trust. So the person receiving Medicaid can keep about up to $2,700 of their fixed income. So that includes Social Security, pension, and If you have more than that, then you will create what's called a pool trust through an organization called Plan of Connecticut. Plan of Connecticut is a nonprofit, and it's been authorized by the state to manage these trusts. You would come up with what's called a spending plan that gets approved by Plan of Connecticut to cover living expenses that are associated with living at home. So you're putting your excess income in there, but it can still be used to help pay for living expenses. If you have money at the end, if you pass away and there's money left in that trust, then that money can go towards, has to go to repay the state for what it's paid for your care. The state will also, they're also concerned with or want to look at whether or not you've made transfers of assets. So whether or not you have transferred assets within the 5 years prior to your applying for Medicaid. And that does not include transfers to spouse, which we will get into in a few slides. And so why is home care important here? Because Connecticut is trending home, because the number of beds in nursing homes is declining, and because people really want to age in place. That's what we hear from the majority of our clients. They want to stay comfortable living at home as opposed to going to a nursing home. So fortunately in Connecticut, we have what's called the home care program. So the home care program for elders there's different components of the program. One is funded by Medicaid. So it's funded by Medicaid dollars, federal dollars. Applicants must be 65 years of age or older, must be living in Connecticut as a Connecticut resident, and must be at risk of nursing home placement. So this program you must also meet the program's financial criteria. So this program is brought about by the Medicaid waiver program. What was happening is that the states were seeing that the cost of going to a nursing home was just so high and people wanted to stay at home. So the Medicaid, what happened is they created these Medicaid waivers that said you can use the Medicaid federal dollars at home as long as you meet these certain requirements. So these are for people who would otherwise be in a nursing home, but can live at home with assistance and care. So you have to be at risk of nursing home placement. So what do we mean by that? We mean that the individual needs assistance with daily living skills. So this is as opposed to medical care. This is assistance with bathing, dressing, eating, taking your own medications, toileting, cooking, those types of things you must require assistance with in order to qualify for this program. Now, it's important to note that the home care program for elders through the state of Connecticut also has a state-funded program, a sub-program under it. So you've got either the federally funded Medicaid program or the state-funded. The state-funded does allow people to have more than $1,600. However, the funding the care is more limited, and there is a copay associated with that program. So sometimes when people have not completely spent down, or maybe they only require a few hours of assistance living at home, they may start on the home care state-funded program and then switch over to the federal Medicaid program at some point in time. The services that are available under the Connecticut home care program include care management services, adult day health, companion services, home delivered meals, and home maker services. So that's all potentially included underneath the home care program for elders. So when we're talking about setting yourself up so that you can age in place and you can stay at home, there's a few steps that we're going to highlight in this presentation. And one is to get your estate plan in order. So what we mean by that is there are two very important documents that are needed during lifetime for everyone. And that is the durable power of attorney and the healthcare document. And in 2016, the power of attorney statute was modified and to include additional powers that we often use or to take advantage of within the asset protection long-term care context. So they're called what's called hot powers. So there are things such as allowing your agent to be able to transfer assets out of your name, allowing your agent to be able to change a beneficiary designation, allowing your agent to be able to create a trust for you. So we can, as you'll see in a few slides when we start getting into some of these strategies, if you're incapacitated and are incapable of executing these strategies, your agent would be the one doing it for you. And this is what we often see. We're working with people's children because they're not able to execute some of the things that we need to do in order to be able to preserve or protect assets. So without these powers in the power of attorney, your agent would not be able to do them and on your behalf, and we sometimes can be stuck in that we cannot protect the assets like we would want. So the durable power of attorney is a document that should be updated. It should be updated. We typically say about every 5 years to revisit it and update it. And part of the reason is also to get a fresh date on it so that your agent does not run into issues at the financial institution they're going to. And part of the reason is because, quite frankly, we see that people change their mind about who they may want to serve as their agent, and they don't get around to actually changing the document. So they may even forget who they named at one point, and they're surprised to see that that person might be making financial decisions for them. The other document that's important during lifetime is your healthcare directive. The healthcare directive is the document where you're naming someone to make healthcare decisions for you if you're not capable of making them for yourself. So that is your healthcare representative. It may also include a section addressing a living will, which says that if you're in a permanent vegetative state, that you don't want to be kept alive indefinitely on machines. So that's an important, if those are your wishes, that's important to put that in writing so that everyone knows that. So those two things are important for lifetime. They're things that we often rely on when we are trying to get someone on Medicaid, trying to preserve assets. And the last document is the last will and testament. So a will or a trust, something that addresses what will happen or what you want to happen to your assets after you pass away. So that's step one. So step two, when we're talking about aging in place, is coming up with a plan, being proactive, coming up with a plan to protect assets so that you can qualify for Medicaid. You don't need to spend down to the lowest level, and you can ensure, which is important for some people, that you're leaving a legacy for your children. So when we talk about proactive planning, a lot of times we're talking about protecting assets, and for many people, this is their house. So their house is for many people, their primary asset, and they want to be able to protect it so that there's no estate recovery, and they're not, in some cases, forced to sell it if they have to move into a nursing home. So the key thing to remember when we're talking about proactive planning is that any type of transfers of assets or any type of strategy, you have to be mindful of the 5-year look back period. And what that means is that if you do require long-term care and do want to apply for Medicaid, then the state is going to ask if you have made transfers of assets within the past 5 years. For every $14,524 that you have transferred in the prior 5 years, the state is going to say that although you have to be otherwise eligible, so your assets have to be below where the 1,600 limit. So although you may be otherwise eligible for Medicaid, you've made these gifts. And so the state is going to impose a penalty period. And so for every $14,524, the state's going to say, we're not going to pay for your care. we're not going to pay until the penalty period runs. So it's the total value of the gifts made in the 5-year period divided by the penalty divisor, which is the 14,524. That gives the number of months where the state will not pay for your care. So that's why that proactive planning can be very important, because although 14,000 may not seem like a lot in and of itself, if you've transferred a large asset like a house, you're going to get a multi-month penalty period, which is going to result in hundreds of thousands of dollars. So the way we typically go about protecting a house or potentially other assets is to create a trust. It's a special kind of trust. So for those of you who may already have trust in place, they may or may not satisfy the requirements of this. So for many people who have done revocable trusts as part of their estate planning as an alternative to a will, that's not what we're talking about here. We're talking about an irrevocable trust where you set it up as the grantor, but you cannot be the trustee. So with a revocable trust, you're still maintaining control. With the irrevocable trust, you are not. You're maintaining indirect control. So you cannot be the grantor. You cannot be the trustee. I'm sorry, you are the grantor, but you cannot be the trustee. So you can't be the person managing the trust in control of the asset. You also cannot be the beneficiary. So these are the parties to a trust. You can only be the grantor here. So how does it work? So the asset protection trust has to be irrevocable because you have to, basically, you're setting up a wall between yourself and the trust that contains the assets. You cannot be the trustee of the trust, but you can name family members or others to be able to manage the trust. Typically, you will name your children or whomever your estate planning beneficiaries are as the beneficiaries of the trust. As long as the house stays in the trust for 5 years after the transfer, the house will be fully protected for the purposes of Medicaid eligibility. So in other words, when the state is asking for what are your assets, this asset is not considered yours. So it's not, doesn't count towards the $1,600. The $1,600 is, at the time of application, you can only have $1,600 in your name of assets, just to clarify that. Once you pass away, your irrevocable trust has the provisions in it similar to your will or revocable trust that says what you want to happen to the assets in that trust, who you want them to go to. So it functions like a will at the time of your death at that point. So we often get the question, why can't I just give my house to my children? Why can't I just quitclaim it to them? And then as long as I make it past the 5 years, the house will be protected, just like the trust situation. So the answer is that yes, you can absolutely gift your house to an individual versus a trust. But the important thing to think about is that when you transfer an asset to another individual and it becomes theirs, so legally it's their asset, that means that it's subject to whatever's going on in that particular individual's life. So here are some of the risks that you'd be facing by just simply transferring it over to another individual. So what if the child passes away unexpectedly? So you are really giving up control of this asset because it's legally in their name, and if they pass away, then it's going to pass in accordance with their own estate plan, if they have one. If they don't, it's going to pass by the laws of intestacy. So for many people, what that means is if you've transferred your house to a child and they're married, that house is going to probably pass to their spouse if they die. If they die and if you're still living, it's going to go to their house. It's not going to go to the people that you've want it to go to. So what if you have a falling out with your child? What if there's an argument? What if there's a situation where you're not speaking to your child? They own your house. You can't sell it without their consent. You're in a situation where you're really, you're not able to do what you want to do with respect to the house. What if the child is involved in a bad accident and they're sued? Their name is on the house. So the creditors, you can be sure, are going to go after that asset. What if the child gets divorced? Same thing. Will it be considered a marital asset? Will their divorcing spouse try to get access to it? And then the other thing is, what if your children have a falling out with each other? So if you've got multiple children and you've gifted it to all of them, what if there's a situation where they're not getting along? So these are all the types of things that can come up and sadly do come up, and they can all be sort of protected against by using a trust versus just gifting it to an individual. Because with the trust, the house is in the name, it's titled in the name of the trust. So it's not subject to a beneficiary's creditors and whatever's happening in their own lives. And you do maintain some indirect control of the house that's in the trust. And here's how. Because you're naming trustees to a trustee or trustees, you can have co-trustees of the trust, and they're responsible for the assets in the trust. But you retain the right to change the trustee. So if you decide that you want to sell your house, the house that's in the trust, and the trustee is refusing to do it, you can always remove that trustee and replace the trustee with someone else. So in that way, you're maintaining indirect control. You also are the one who determines and spells out how the assets should be distributed once the trust is terminated. So many times that means at your death. So rather than have it potentially pass in accordance with your child's estate plan, you are maintaining control of who it goes to. So those are some of the benefits of the trust versus gifting it to individuals. So we hear this a lot where clients say, my house is already in a trust, so I'm all set, it's protected. And again, a revocable trust, which again is more similar to, think of it as a will substitute. So it's really about indicating where assets are going to go at the time of your death. And it's not an asset protection tool. And to just kind of explain that in a little bit more detail here, you see that a revocable trust, when we're doing revocable trust for our clients, we are most commonly using them to avoid probate, which is a particular issue if somebody has property out of state. If they're concerned about wanting to get their assets to their beneficiaries more quickly, then the avoiding probate might be something that they are interested in. If they are wanting to keep their affairs private, because a will and a probate process is public, so people can request copies of your will, of your, the assets, the listing of the assets that are in your estate at the time of your death. A trust can keep that private from if you have children who you've disinherited, if you have perhaps given people disproportionate amounts of assets, the trust can help keep that information private. We the revocable trust is helpful in incapacity planning, where you're naming someone as your trustee to be your successor in case you can't do it for yourself. And you also have, for people who have estate tax exposure, we can incorporate some estate tax planning. So those are some of the reasons why we might create a revocable trust. Very different from the irrevocable trust. So while the irrevocable trust will also avoid probate because the house is going to be owned by the trust and then pass under the terms of the trust, the irrevocable trust has the asset protection component, where, again, as long as the assets are in the trust for for 5 years, they will be protected from creditors. Okay, so step 3. So what happens if someone requires long-term care? Perhaps they didn't do some proactive planning, and the good news is that we can still protect assets. So what we have here is Medicaid financial eligibility. Again, we talked about the asset limits, the income limits, and the fact that transfer of assets is something that the state will look closely at. So we have here, just to provide some examples here, scenario 1, where we have here George, who is feeling younger than his years and is trying out skateboarding. And unfortunately, he falls and breaks a hip. So here George is looking at, he's got assets about $150,000 plus his home. He enters a nursing home to rehabilitate his hip. And the recovery takes a little bit longer than was originally expected. So if he were to be paying out of pocket $15,000 per month, he will run out of money in month 10. If he is not able to return home, he may have to sell his house in order to pay for more care at that point because he's run out. So does George necessarily have to sell his house in order to get on Medicaid? Here, so not necessarily, because the house is not considered an available asset if somebody's living in it. So if a person or a person's spouse is living in their house, they do not need to sell it. They can qualify for Medicaid. What happens if he wants to return? He intends to return home. If he intends to return home and you can show the state that he will be able to return home, then it will not be considered an available asset. But it's sometimes in a situation where someone needs to get on Medicaid, they're not going to return home, but they still have the house, but they've run out of cash. So they need to get on Medicaid. And let's say the house just isn't selling. As long as the person's making a good faith effort to sell the house, so the house is on the market for fair market value, then the person can still qualify for Medicaid and Medicaid can start paying for care. Once the house sells, however, the George here would have to spend down the proceeds in order to be able to qualify for Medicaid. So in a market where the houses just aren't selling, it would still allow him to get on Medicaid and still be able to qualify and get his costs covered. So what about home care? So as I said, the Medicaid we have a Connecticut home care program for elders where Medicaid benefits can be used to pay for home care. So in this situation, you can keep your house. So again, you're living at home, you're receiving care at home. So the house is an available asset. It's not counted towards the $1,600 asset limit. However, when you pass away, the state can try to recover against your estate. So the state will put in a claim to get repaid for what it has paid on your behalf. And in that way, it can recover against the value of your estate, which would include your house at that point. In addition, if you transfer to a nursing home, so even if that's not your plan, but at some point you need to transfer to a nursing home, the state is going to expect that you're going to sell the house in order to pay for your care. So that's going to be the expectation. So what about a married couple? So that's a little bit different because in this situation, we'll show here, we have George, and let's say we have his wife, Sophia. So together, as a married couple, they own $150,000 plus their home. George is injured, needs to go into a nursing home, but his wife is still healthy and she's still living at home. So as I said, because either the applicant or the spouse, as long as one of them is living at home, it's exempt. It's an exempt asset, it's not counted against them. So we know George can keep only $1,600 in order to be able to qualify. So what we'll have to do is we'll have to transfer the assets over to Sophia because to get him down to the 1,600. So what can Sophia keep? She can keep one car, and then she can keep what's called the community spousal amount, which is 1/2 of their total assets. So you take the assets of both spouses. It does not matter whose name the assets are in. It doesn't matter if they're tied up in a retirement account. Those all count. So it's the total assets of the two spouses. And then you will divide them in half. And the spouse can keep up to $154,000, $154,140. Above that, she would need to spend down before George could get on Medicaid. So what if you take their assets, if 1/2 of their assets equals less than 50,000. So let's say they've got a total of 60,000 in assets, not including the house, and you divide that in half, which means that they have 30,000. So in this case, the state says you can keep, the minimum is 50,000. So the state would allow them to keep 50 instead of 30. And then the spouse would have to spend down the remaining 10, because remember they had 60,000 in that example. Sophia can keep her income, whatever, so she can keep her Social Security. If she has a pension, she can keep that. She may be able to keep some of George's income. And again, this is in a nursing home type situation. She may be able to keep some of his if she can show that her living expenses exceed a certain amount. So that's a possibility. And then George can apply for Medicaid right away. This is in a nursing home situation. What if George wants to return home and he wants to apply for Medicaid so that he can stay at home, so he can pay for someone to come to his home and help take care of him at home? So in this situation, it's the same with respect to assets. That Sophia can keep 1/2 of the assets with a maximum of $154,140. If her assets, if 1/2 of her assets are less than 50,000, she can keep 50,000. She can also keep the house, she can keep one car, and she can keep her income. Now, in the home care situation, the George would be able to keep, again, his income up to about $2,700. And then anything in excess of that would have to go into a pool trust, which is what I was explaining earlier with Plan of Connecticut. And that money can be used to pay his portion. So the money in the trust can be used to pay his portion of their combined living expenses. Okay. So spending down. Spending down. So when we talk about spending down, we talk about getting someone down to the necessary asset amounts. And here's the types of things that someone can do. So a lot of times, if the plan is to stay at home and to age in place, there could be home improvements that are needed in order to make that happen. So remember, if you're trying to spend down assets, and you're wanting, as long as you get something in return. So sometimes people will say to me, well, if I'm trying to apply for Medicaid, can I make an improvement on my house, or can I buy this? Can I buy that? You can buy whatever you want as long as you're getting something for fair market value. What you can't do is you can't gift your money. You can't pay for something that's not equal in value to what you've paid, because that could be considered a gift. So with home improvements, sometimes we recommend, it can be helpful for people to bring in someone like a geriatric care manager which is usually someone potentially who has who is a registered nurse or perhaps a social worker. But they are people who will come into the home. They will do an assessment of the individual in their home environment, and they will make suggestions about maybe some things that can be done to the home to make it more comfortable for someone to be able to age in place. So home improvements, I mean, obvious ones are making things more accessible, changing the shower, making some other changes so that someone can stay at home. Other things include things that may not be covered entirely by Medicare, dental work, prepaid funerals. That's something that you can get an irrevocable funeral contract through the funeral home, which will basically convert an available asset, which is cash, into an exempt asset, which is this irrevocable funeral contract. And it will cover the cost of your funeral at the time of your death. So we often recommend that people purchase those funeral contracts. You can also upgrade your car because remember, you or your spouse are allowed to have one car. So for people who have been putting off upgrading an old car, that might be something that they might want to do at that point. So spousal transfers, I often get a question from people where they say, well, wait a minute, you said that you can't make transfers of assets within 5 years. The exception is to the spouse. So oftentimes when we're want to get a spouse onto Medicaid, we will have to transfer assets to the healthy spouse. Because again, the person applying for Medicaid can only have $1,600 in assets in their name. Some other types of transfers that are considered exempt are transfers to a disabled child or transfers to a caregiver child. So if you have a child who is on Social Security disability or SSI, you can transfer assets to the disabled child, and that will not be considered a gift. So that's an exception. Another exception is a caregiver child. In that case, if you've had a child who has been living with you for at least 2 years prior to your needing long-term care. So they have to have been living with you and they have to provide evidence that they've been living with you. And they have to have been providing care to the extent that without the care, you would have needed to go into a nursing home. So it's that level of care, and you will need to get something from a doctor stating that. So if you can show that, if you can show that the child has provided that care, that level of care for 2 years, at least 2 years, then you can transfer. Many times people will transfer a house. You can also transfer other assets to the child and not have it count as a gift. So in other words, it will not cause a penalty period. So this is just to highlight here an example where you have a married couple who funded an irrevocable trust. So they took advantage of the proactive planning. They gifted their house to an irrevocable trust. They made it past the 5 years, but then one needs care. So they have $500,000 in liquid assets, and they've got a home. Their home is worth $400,000. Their home is sitting in the irrevocable trust. So what can they do? Can they protect additional assets? And the answer is yes. So here in this situation, the husband needs to go on Medicaid. And as we said earlier, wife is living in the community. She can keep the house and the car. She can keep a house, a car, and she can keep up to $154,000 in assets. So what she can do is she can actually purchase the house from the trust. Has to be for fair market value. So the trust is this separate entity. It controls the house. It has the house in it. She uses her liquid cash to purchase the house. The house goes back into spouse's name and the money is sitting in the trust. And because this is an equal swap, we're not jeopardizing that 5-year look back window. And because the wife is allowed to have a house at this point in time, and the house will not count as an asset, then spouse can qualify for Medicaid because now she's down to where she needs to be with respect to her assets. She has a house that doesn't count. So she's left with 100,000 of her assets, which is less than the Medicaid max of 154,000. So she's met the asset limit. She has the home, but the home is exempt, and she meets the Medicaid financial eligibility for the community spouse. So now you might think, well, but now what about the house? We just you protected it by putting in the trust, and now it's unprotected. So where does that get her? After the Medicaid application is granted, the trust can buy back the house for 400,000. So the trust gives the 400,000 back to spouse. She can use that to live off of, and the house is still goes back into the trust, and it's protected in case wife needs to go on Medicaid at some point in the future. So this is one of the strategies that we have used with clients at our firm. We also can, another type of strategy, and this is called what we call a crisis planning strategy. So this is for a situation where maybe you put your house into a trust, but you have other assets that you want to try to protect at the time of needing long-term care. Or maybe you didn't plan and you didn't put assets into a trust, or you didn't get them out of your name, and one of spouses needs long-term care. What we can do, I'm going to skip that slide, is we can use what's called a SPIA. So it's a single premium immediate annuity. And the purpose of this is to convert excess assets into an income stream. And this is something that we use oftentimes with married couple. So as I said before, you have an ill spouse who can have $1,600, and you have the community spouse who can have up to $154,000. What if spouse has more than that? The community spouse has more than the 154. So the options at that point are that she can spend it down. So she can spend it down to the 154, get to where she needs to be, then they apply for Medicaid. However, a lot of times 154,000 may not be sufficient, especially if you have a young or relatively young, healthy community spouse who's living in the community. Depending on her income, 154,000 is not going to be enough. So what can we do? We can use an annuity to be able to convert the excess assets into an income stream for the healthy spouse. There are some requirements for this annuity. So it's not your typical life insurance annuity where you're putting down a lump sum and you're trying to stretch it out so you have an income stream for lifetime. What we want to do is we want to establish this annuity so it pays out in a compressed kind of fashion. The annuity has to be non-assignable, which means you can't assign it to someone else, you can't sell it. It has to be irrevocable. So then, in other words, you can't change your mind and cash in the annuity. That's not possible. Has to be actuarially sound, which means that it has to be set up so that it's paying out in a period that does not exceed the annuitant's life expectancy. So, and that's just based on tables, actuary tables. And then the other key component is that the state has to be the remainder beneficiary. So if we set up this annuity for the community spouse and she passes away and there's money left in the annuity, it pays back the state. So these things have to be, these components have to be there in order for the state to accept this type of annuity in a Medicaid asset protection strategy. So here's an example of how that works. So here we have husband and wife. They jointly own a house and a car, and they have 500,000 in liquid assets. So they, this is similar to the example we provided before, but they didn't put the house into the trust. Husband needs to go on Medicaid, and the wife is entitled to keep the house and the car. And this should say 154,000 because this is an old amount. So she can keep 154,000 in assets. So wife has 350,000 in assets. So she's over the amount. So what does she do? So there's some home improvements that they've been intending to do. So they're going to get those done. So they're going to fix up the bathroom. They're going to maybe expand some doorways. They're going to do some other things to make it more comfortable to be able to age in place at home. They're going to maybe take care of some dental work. They're going to get their prepaid funeral contracts in place. So now she's got 300,000 left in assets, still over the amount that she needs to be at. So she's 300,000. The 300,000 is annuitized for the wife. And this is based on her life expectancy, which is typically about 5 years. It can be shorter than that, but here we're just going to use a 5-year example. So she's got 300,000. It's annuitized over 5 years, which leaves the wife with an income stream of $5,000 per month. Because remember, there's no income limit for the wife. She can keep all of the income as long as at the time of application, she's under the asset limit, which this would do for her. She can then receive the income every month, and she can save it back up. And the husband will be financially eligible for Medicaid. So instead of having to spend down all that money on long-term care, they've protected it using this annuity strategy. It's important to note that for a single person, so someone who's not married, the annuity does not work for someone who is at home. So we could potentially use it for someone who is in a facility, a skilled nursing facility, but it's not available for someone who's getting home care at home. Then just one final thought, and then we can move on to questions, is just the Medicaid application process is, as you can see, especially if you're looking at asset protection strategies, it's complicated. There's only attorneys can do some of this work. So for people who are not attorneys, they may not be able to implement some of these asset protection strategies. So you may want to, we urge you to consult with an attorney for when you're looking at Medicaid applications, particularly with asset protection involved. So how about questions?
Thank you, Erin. We do have one question from Francis. What about asset protection strategies if you are a widow or widower?
Okay, so I think that means you want to protect assets at a time where your spouse has already passed.
I believe so.
So you're sort of like at that point, you're sort of a single person. So it kind of goes back to the scenario where, is it likely that you have 5 years so that you can take advantage of some of the proactive planning where you're transferring assets to a trust? So that would be, a possibility. And if you're not in that window, there may be some crisis planning strategies that can be used, and it really depends on the cost of care. So we can, gift with we can gift with an annuity, or we can make a gift, and some of the gifted money can be used to pay through the penalty period. All of that has to be done looking at the actual values of the cost of care and the assets that you have. But those are some asset protection strategies that we can use for a single individual.
Does anyone else have any other questions for Attorney Duques? You can drop it in the chat.
Yes, please feel free to. I guess this means that I covered everything. Sometimes I take questions throughout, but sometimes it gets tricky because people are, anticipating things that that's going to be discussed eventually. So,
Right.
um,
Well, thank you so much, Erin. That was a
okay.
really wonderful presentation. And thank you all for joining us today.
Yep. And my information, sorry to cut you off there, Elizabeth.
Oh, no, go
My
ahead.
information's here. So if you think of a question that as you go about your day, you can feel free to send me an email, and I'd be happy to address it for you. Okay.
Thank you.
All right. Thank you. Have a good day, everyone.
You too.